Hi, Bill Hammond here with the Elder Law Question of the Week. Had a very interesting client meeting a couple of days ago. Sat down with a married couple. He has some early dementia, and she brought him in and just wanted to be sure that all of the planning that they had done a few years ago was in order. And she insisted that the trusts that they had set up protected the assets which are in her trust. So I said, let me take a look. And I took a look and discovered that they actually each have what we call a revocable living trust. And that means it's a trust. They each set it up as grantors. They're both trustees. That means the grantors set it up, the trustees manage it. And then at their deaths, assets pass to themselves and then on down to the kids. Makes sense from the perspective of planning to make sure those assets go where they're supposed to when these folks pass away. But she was quite distressed to discover that this did absolutely nothing to protect those assets in the event he needs long-term care. Now, the good news, he's fairly early on in his stages of dementia, and they're going to have time, I believe, to fix this and make everything right. But I thought it was a good opportunity to remind everyone, if you have a revocable living trust, that's a great thing to do to make sure that your assets pass where they're supposed to when you're gone. But you've got to have real good Medicaid planning language in there, and you've got to set them up in just a certain way to make sure that those assets can be protected in the event one or both of you need nursing care. Now, if you've got any questions you'd like me to deal with, please go ahead and send those in. And otherwise, have a great day, and I look forward to talking with you next week.